You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Our guest today is Joseph Wilson from Atlanta, Georgia. And Joseph has been on the podcast before. I can't remember if when he was on the podcast before, if he was already part of Wilson Rowley, which is Trial Lawyers for Justice Georgia, or not. But regardless, Joseph and Nick are partners down in Georgia and doing some great things. And Joseph, welcome back to the podcast.
Kenny, I appreciate you having me back on. I was waiting for that call for these last few years, man. I'm glad you made it so I could get back on with you.
I kept dialing the number. I couldn't get any answer till recently. So I'm so glad you finally picked up when I showed up at your house and made sure you had the phone in your hand.
Yeah, I had you blocked for a while, man, but we're good now.
It was the other Kenny Berger, and it was the other Joe Wilson. We had our wires mixed up.
That's all.
Hey, it's good to see you. Congrats on all the successes. We're going to be talking about closing arguments today. And anybody who knows you or has seen you try a case knows you excel in a courtroom and that you really kind of come alive and bring it all together. And in closing, we had Brian Ward, who's going to be talking about rebuttal in the episode after this. But for you, let's start where you want. When it comes to closing, what do you find to be most important? And let's just have a conversation about it.
Sure. So yeah, closing it's a tie between that and opening statement, which is my favorite part of the trial. If I had to choose, I'd probably lean more towards closing because that's where you can really argue the case and, really show that passion and let that come out of you as a trial lawyer and show why we all became advocates. I think, when we were younger and wanted to become trial lawyers, we were looking at closing arguments. We were reviewing those transcripts. We were looking at the videos online that we could find from the greatest trial lawyers that there are. And it was probably a closing argument. So that's definitely my favorite part of the trial. And when I kind of think about the specifics of a closing argument and what the most important part is, it all comes down to damages, like in any case. The non-economic damages, those assets that are so valuable to us. And we realize how valuable they are when they're taken from a client or taken from someone that we know and love. So yeah, non-economics and how to amplify damages in closing argument and how to really help the jury understand why it's such a significant value. That's probably my favorite part of a close.
Yeah, so let's break down a little bit on the non-economic side. Those damages to the human being's life. What are you doing in advance of trial and during trial to best position you to make those arguments during your closing?
Sure. So in advance of trial, of course, you're meeting with the client, you're sitting down with the client, and really on multiple occasions. It has to be on multiple occasions. You have to get to know them well enough so that you can really understand what was taken from them. And then once you've gotten to know them well enough, you get to know the folks around them well enough as well, because they're going to give you some more nuggets that you can use to present to a jury and really explain what was taken from them as well. And so once I've got a good grasp on what was taken, who they are as a person, who their family and friends and who are close to them, and what they have to say as well, then I really try to internalize it. And I try to picture, this person as, let's say it's an 80-year-old woman. I try to look at that person like that's my grandmother, which is very hard to do. And it emotionally, it changes things for you. Obviously, you become close to your client, but once you look at them as your grandmother or your child or your spouse, that's a different type of emotion. And I do that because I want, when I'm in front of that jury, when I'm talking to that jury about this person's damages, I want them to know that I really care and then for them to understand how important this really is. And you can't really express that type of emotion and authenticity unless you're really feeling that. So that's a bit of my methodology. In addition, as I'm going through, let's say I'm trying a case in Georgia, I'm going through the elements of non-economic damages. I'm trying to figure out what are some different metaphors or analogies or stories that I can tell about this specific element to the jury before I get into the specifics of my client's non-economic asset that was lost. Because that way they're starting to look at it in a broader view and even relating it to their own lives before they're thinking about this other person's case and what happened to them.
Yeah, and I love the idea of breaking those things into their different parts. I mean, I think it's easy to talk about damages or non-economic damages, and you lump them all together, and then in my estimation, you start getting kind of haircuts or deductions and reductions all over the place. But once you break them out and you establish the value and the importance and just how deeply this person cared about whatever it was that was taken from them or damaged in their life. You talk about the value of that. And the next thing, it's like, I think for people, especially in the South, and really all over the place, not just the South, but if you were getting a construction project done at your house and the GC was like, all right, Joseph, it's going to be $100,000, you'd be like, that sounds about right, but what's that for exactly? And once they start showing you what's for electrical, what's for plumbing, what's for drywall, what's for all the different things, it all starts making a lot more sense. And it's the way for anyone who runs a practice, the way that Joseph does and I do, it's how things start adding up real fast. But the same is true in our cases when you go through and not just lost enjoyment of life, like you were pointing out, or physical pain or suffering, but the subparts of each of those. And you did a great job when you came to Hilton Head and spoke to our trial lawyers conference a couple summers ago, on not just talking about what their life was like before and after, but really getting specific on how were they doing the day before? How were they doing the morning of? What did life really look like? Down to the, how they went about showering, how they went about walking to get to their car, how they went about driving to get to work, and then all the things that were taken from them through no fault of their own.
Yeah, exactly. And even when you start to break down those different elements and then you're including the longevity of the pain, now things start to stack up. But you brought up a good point, and you may do this more in opening, but you'll bring it back and circle to it in closing. But how was this person doing when they woke up that morning? And of course, I stole this. I got this from Nick. We tried a case in Cherokee County 2 summers ago, and it was a pre-existing case where he had not a lot of pre-existing issues, but about 7 years prior, pretty significant pre-existing history. And so we wanted to put that in context. So we had to explain, okay, what was it like the day you got up? How were you feeling? In this case, he was feeling completely fine, no issues whatsoever, no back issues. And again, we kind of point that out to put it in context for the jury that this was a guy living a normal life and that it changed that day.
And I think, the defense loves to talk about generalities.
Yes.
And in cases like this, people don't get hurt, but they hate talking about the specifics oftentimes of our client in our case where someone did get hurt. Joseph, what do you like to do? We've talked some about non-economics. Where are you on economic damages?
Well, if you would have asked me maybe a couple of weeks ago, my opinion would have been different, at least in Georgia. But we have had some tort reform or whatever they want to call it, some litigation, fraud, BS, or whatever. A lot of nonsense. But now I would say, I still would put in economic damages. It depends. If they're significant, if I believe the bills are reasonable, then I'm going to put them in as is. Sometimes I have a case, it may have gotten referred to me where I look at the bills, they look good. It's $500,000, but I'm like, this is not going to stand. So a lot of times I'll The defense may have an expert who says those
You know,
bills should be.
you know what I kind of heard? What I heard was like, oh, they went to a surgery center in Florida and got a $300,000 surgery that everyone knows costs 30 grand.
Exactly, something like that, or and then a couple injections for 200 grand or something like that. It's like, come
Yeah.
on, guys, like how with stuff like that, if the defense has an expert who says the number is a different number, sometimes I'll stipulate to that because I don't want to be in trial arguing over past economic bills. Now, again, if they're legitimate, that's a different story, or the future expenses are legitimate, that's a different story. But if I don't believe in them, I'm not going to argue that they're reasonable to a jury. I'll either waive them or stipulate to another number that we can agree on with the defense as to what is reasonable.
Yeah. Another kind of nuts and bolts issue that I don't think we've talked about as much on this podcast, at least not recently. Where are you with having your client there or not there, especially during closing?
Yeah, depends. So yeah, and it really is very case specific. So Nick just tried, I was out in California where he was the Starbucks case, where the guy's growing area got burned severely, and he was there a good amount of the trial. When they started putting on expert testimony where they're talking specifically about the function and things of that nature and how it's going to be in the future, he left. Frankly, he was getting sick, literally nauseous, hearing about it, and then a lot of times in closing he couldn't handle it. So it really depends on the client. It depends on the type of injury as well. If you got like a spine case, a disc injury case where your client's been complaining of chronic back pain, not being able to sit still, and things of that nature, being uncomfortable, you got to be very careful because the jury is going to be paying a lot of attention to your client anyway. And now they're going to be hyper focused on, okay, let's see how they're doing over there. How well are they sitting over there? Are they smiling too much? Are they this and that? They're going to be nitpicking the hell out of them. So in that case, it may be better to have them leave the courtroom for certain periods of time, or periodically have to get up and leave.
I think
It
that's a
just
great point. And it feels like anytime that the jurors are treating your client like an exhibit, the less they can be there, the better. When that's not really the issue, um, and there's a need for a human face on it, yeah, I'm okay with them being there for parts of it. But if they're going to get
right.
treated like an exhibit, it's like, no, man, because there's
No.
nothing you can do right. You either look too hurt, you're not hurt enough, you're too happy,
Yep,
you're milking it. Yeah.
exactly. You can't
Not
win.
where I want the microscope.
No.
Um, just is there a structure that you like, a kind of a loose outline, things that you make sure you're always wanting to do in your closings, be it juror empowerment or otherwise?
I would say there's not really a structure anymore. It's depending on how the evidence comes in, what the defense is doing. Are they doing a bunch of crap that I know is pissing off this jury that I know is a lie? Do we need to try the lie, as we've heard before? So it's dependent on the case. Of course, there's certain things that we're going to always hit, burden of proof, things of that nature. But generally, I don't have a structure anymore. I try to be more fluid, and um, although I have certain things that I know are going to come into evidence. Like we all have things we know that are going to come in. I might start putting that in different parts of the closing as I create my slides. But as far as the structure, the way I'm moving things around and when I'm going to talk about things, that's different from case to case nowadays.
And Joseph, for younger lawyers, I want to make sure that we're clear that just because you're not as structured or have as tight an outline per se, it doesn't mean you're improvising and unprepared.
Exactly. You're definitely prepared. As far as the order of things, that's what I mean by structure. Introduction, burden of proof, economics, non-economics. That's what I'm talking about as far as order. My order, I don't have an order anymore. I may talk about things differently and from a case by case basis, but generally speaking, I'm going to talk about burden of proof pretty early on. I'm going to say how we met our burden, and then I might get into some of the evidence. And the other key thing, I think, with closings, because you see a lot of lawyers who are rehashing really too much evidence. They're rehashing almost everything that was heard in the trial. I like to tell the jury, I'm not going to rehash the evidence. You've heard it, you've taken great notes, but I'm going to touch on some of the highlights. And I'll specifically say that. We've all heard the term highlights, and we think about it when it comes to sports. We're hitting the high points and we're going to be more efficient. And I think when you tell that to a jury, they know they're not going to be there for 3 hours if you're just highlighting some of the key things that they heard.
Yeah, I think that's excellent. I like that. I'm going to borrow that.
Hey, take it away, brother. I've heard things from you before, so.
Let me ask you this. I mean, it got me thinking about, highlights and from sports, and you've got a sports background.
Don't
When
tell the
you're,
basketball story from Montana. We don't have to go there. I just wanted to let you know, you don't have to bring that up, by the way.
it's timed out, man. I'm just glad I made it to the finals with you. I was literally just happy to be there in the finals of an epic horse game. Yeah, but I could not overcome talent, and eventually, law of averages, made sure that the best player won. But thinking about, I grew up playing a bunch of sports and with a dad who went to Vietnam and is a World War II kind of amateur historian. So, my whole life it got beat into me. Sports and military analogies, which again might not be the things that you want to emphasize during a trial for obvious purposes or reasons. But when you're preparing, we've never talked about this before, but will you talk some about how your background as an athlete shapes the way that you view trials and view closing argument?
Yeah, it really does. I mean, I think about that a lot, actually, because I think that's one of the reasons why I gravitated more towards trial law. Is it's the closest thing to that kind of competitive you against me type scenario that you only get in competitive sports. And I've long since stopped playing competitive sports. So yeah, it definitely shapes that for me. And when I'm preparing for trial, when it's the same with sports, you're preparing your body, you're running suicides, you're working on your jump shot, you're mentally preparing yourself for your opponent. Same thing when it comes to trial. It's the physical preparation, eating correctly, working out, making sure you have the energy to try a case for a week, but it's also the mental preparation. So, I can think about the first time when I get up to speak in court. My people ask, do I still get nervous? Yeah, sometimes I do. And I can feel it in my body. I can feel those nerves. And I'm like, all right, now it's time to start really talking myself through it. And so I really will tell myself I'm the best trial lawyer in this courtroom. I'm made for this. I'm really hyping my own self up mentally in my own head so that I can get up and do this and do it to the best of my ability. So sports and trial go hand in hand, when it comes, for me at least.
Yeah, and so kind of in that same concept, how do you view your role vis-a-vis the jury?
Yeah, my role. So I think it changes in different parts of the trial. So in voir dire, they don't know me. So I want them to get to know me a little bit, and I want to get to know them as well. So I try to be myself. I don't try to inject humor where it shouldn't be injected, or that's not natural, or something that I wouldn't naturally say. I try to put them at ease. I try to talk to them like I'm just having a normal conversation with them. And this hopefully is building my credibility. When I get to opening statement, I'm trying to continue that credibility, but I'm also trying to teach them now. So for example, let's say we have a brain injury case we're trying. At some point during that opening statement, you need to teach them about brain injuries. You need to teach them about the brain, and you need to teach them about different types of brain injuries, and then specifically your client's brain injury. And what that does is continues to enhance your credibility, because now you're in the role basically as a professor, a teacher. And we all know we've had great teachers and professors in our lives. They have credibility. We're learning from them. So yeah, it really it changes and progresses throughout the trial. You're maintaining that credibility throughout your case and the defense case. You're treating everybody politely. You're treating the defense witness, although you may be crossing them and being, sometimes you got to lay the hand down, sometimes the hammer down, sometimes, but you're still treating them with respect, just like you're treating your witnesses with respect, because the jury is going to pick up on that. If you're being mean to their witnesses and super nice to your witnesses, they're going to say, okay, that doesn't match. He's not credible. He or she's not credible. And then by the end of the case, hopefully in closing, they're with you. You have and maintain your credibility. A lot of times the defense has not, and you can point that out to the jury. And so that's what I kind of how I look at my various roles throughout the trial as the trial lawyer.
Yeah, I love that. And I was thinking when you were talking like my favorite teachers, favorite professors, none of them were loud. None of them were, none of them were browbeaters. They laid it out and kind of and basically created a situation where you felt motivated or inspired to push yourself and to, toward the right thing, toward a just outcome, where the parallels are obvious. Just I've wondered before, like when you're talking to the jury and in closing, I think a mistake that I've made before is rather than really trying to empower my good jurors and speak to the folks who may or may not be on the fence, I'll spend too much time trying to kind of deal with the bad ones or convince the unconvincible or deal with defense points that really don't need to be dealt with because either they're going to buy them and be against us or they've already dismissed it. Where do you stand in terms of kind of how you direct or allocate your communications with those 12, if you've got 12 people on your jury?
Yeah, I tend to now spend more time on empowering my good jurors to deal with the arguments that some of the quote unquote bad jurors or kind of middle of the line jurors may bring up. So I tend to spend more time doing that. Sometimes I'll literally create the scenario. Again, we've seen Nick do this. We've seen great trial lawyers do this before where they create the scenario. Hey, if you're back in that deliberation room and somebody brings up X, well, here's how, juror so-and-so, you can get up and say this to that. And kind of have that dialogue in front of the jury, play it out for them. So I tend to spend more time on with the good jurors, but I try to, if there's somebody who I'm not sure about who's in the middle, I'll make sure to allocate some specific eye contact time for them as well. I think that's important to do as well. Now the bad folks or quote unquote bad folks, you're right. There's not going to be much that you can do with them. You have to rely on your good jurors.
Yeah, and I shouldn't say bad. I just mean the people who are against you, the folks who are basically on the other team.
Yeah, exactly. Yeah, bad's not the best word to use. Yeah, just folks who don't seem to be with you or with the defense, or maybe it seemed to be against you from the start of the trial.
Yeah, and I mean one of the things I've seen with with the tort reform battle we've had up here, with what I've seen go on in Georgia, what happened in Florida, the more I've been able to look at these people as folks who just have a different worldview and agenda and goals than I do versus like, these evil bastards, the easier it's been to communicate, I think, in an effective, hopefully at times, if not persuasive, at least reasonable way. But it's hard. It's hard.
It is work in progress.
Every day, man. Every day. What else? What key parts of closing have we not touched on? Which I mean, obviously, we could talk about this for hours upon hours, but I just want to make sure that we hit the highlights.
Yeah, this is less kind of a substantive tip. It's more more technical, I would say. I think folks need to pay attention to how they're using their voice throughout the trial, not just closing argument, but opening statement. Whenever you're in front of that jury, giving an argument, you need to pay attention to how you're using your voice. Are you the same level throughout the entire closing argument? That's a problem. They're going to tune out on you eventually. So you need to vary your tone, vary your inflection, vary your pace throughout your closing argument. Find some time or some points within your closing argument to pause, to let them digest what you said to them as well. Repeat important things. I was always taught to repeat important things 3 times. Make sure you're doing that. These are all persuasive, oratorical techniques that great trial lawyers and great speakers use. So I don't just study great trial lawyers. I'll study various just great speakers throughout history to see how they use their voice to keep an audience of thousands of people engaged for an hour or 2 hours. I'm like, how do they do that? They use their voice. It's how they use their voice.
And a lot of times, when you see some of the greats, they start off kind of slow.
Mm-hmm.
This build and this build and this build, and all of a sudden you can kind of feel yourself starting to invest more and more and more, and then the great ones deliver.
Yep.
They deliver on that crescendo.
Yep. Every time.
What again? Brian Ward's going to be talking about rebuttal, but what do you like for you, save or defer to rebuttal?
Yeah. So that's been changed a little in Georgia now. So you have to state the number in first closing. So I would typically do it in voir dire and opening, but you have to do it in first closing now in Georgia. Otherwise, you can't say the number at all, apparently now. So
That makes good sense.
yeah.
I mean,
So yeah, that was something I guess in the past that lawyers had discretion; they could save it for rebuttal. But yeah, definitely bringing that up in first closing now. Really, I use rebuttal typically for pure rebuttal. It's to backtrack, even in first closing, if I talk about some of the defenses or frivolous defenses, I might touch on them briefly in a kind of sarcastic tone, the way that I talk, because I want the jury to know that these are all BS defenses. But typically for me, rebuttal is pure rebuttal, taking notes on what they're saying, and I'm using it against them, like with the evidence that they've heard in the case. And my tone is typically very different in rebuttal than it is in first closing as well. It's much more sarcastic. Again, that's just my personality. You got to use what works for you, but that's typically how I'm using rebuttal. It's pure rebuttal.
Yeah, and I think something, the plaintiffs' lawyers have gotten in trouble over the years for it. But when you pay attention, defense lawyers oftentimes are just as, if not more, guilty of it, and that's overreaching. Now, yes, jurors might not punish them as much, and perhaps jurors don't punish them as much because plaintiffs' lawyers don't emphasize it as strongly or as succinctly as they can. But every time, every single time, in a anything from a motions hearing, opening statement, witness examination, directed verdict motions, yada, 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 defense closing, that there are going to be overreaches and overstatements that, are great, very fertile grounds for exposing and calling attention to.
1000% agree. It's just the best ones don't overreach, or at least they minimize their overreaching. But you're right. A lot of defense lawyers were overreach. Again, going back to that case Nick and I tried a couple of years ago, the defense got up an opening statement with slides that we screenshotted where they were clearly overreaching and saying things that were not consistent with the evidence. I did the first closing. I'm pulling up those slides when talking about their promises and opening statements, and I'm hammering them with it. So yeah, you have to be paying attention to that throughout the trial, taking notes on when they overreach so that you can punish them with that and bring it back up. Remind the jury, hey, this is important because they promised it to you as officers of this court, and it's not true. And I think that's very important to do.
Yeah. Joseph, as far as upcoming trials, cases you're currently working on, The question my dad loves to ask me, you got any interesting cases?
Yeah, I think so. We've got a few TBI trials coming up here in Georgia. We're working on some cases down in Mississippi involving a cancer cluster where this company was dumping a lot of toxic chemicals in Water Valley, Mississippi. That's not going to go to trial for a while, but gosh, if we can get past summary judgment and get at least a few of those cases to trial, we're going to do it. Working on those cases with Jacob and some local lawyers in Mississippi, Jacob Norman. But yeah, later this year, we've got a medical malpractice case that we're supposed to try in August. Nick, myself, Teresa, Bowen Hatch. So that'll be fun. But other than that, I'll just be enjoying the spring and the summer weather, hopefully.
Yeah, I tell you what, one last question on this, and it goes right to closing. You were talking about making sure you're taking care of yourself during trial, just like you would for plenty type of sport.
Sure.
Uh, you're a father of four.
Yes.
You have a wonderful wife. You do a lot in the community. You're an owner of a law firm. What are you doing kind of to build out parts of your life where when it comes time for trial, you know, you've got enough of a, for lack of a better term, support system in place to where you can be as focused and singular as possible?
Yeah, great question. And I do have a great support system. I'm thankful to my family. My parents live 10 minutes away, so they're very helpful. But it's still very hard to carve out that time for yourself as well so that you can be energized to do this and not overwhelmed and stressed. Because, as a business owner, your mind is going in 1,000 different directions. So I was thinking about this the other day. I'm like, man, when I was trying cases 8, 10 years ago, man, it was way easier than doing it now because it was so easy to focus on that one thing. Whereas now it's just like, but but you do your best, and it's a work in progress. But yeah, just taking that time for yourself, meditating in the morning, meditating at night, praying at night, or whatever you do to get yourself some peace of mind, working out, trying to eat the right foods, especially when you're in trial, and just trying to get as much rest as you can. I got this app called New Calm that I try to listen to help me go to sleep and get the best sleep that I can, because I do see a big difference when I get better sleep. And because a lot of times I'll get 8 hours of sleep, but it's not good sleep. So that's what I try to do, but it's a work in progress.
Yeah, I love it, man. I love it. And I love the point you made too. Whenever I talk to people who are thinking about hanging a shingle, entering a partnership where they take on some of that ownership and management responsibility, and I'm like, it's great, but just know that you're taking on a whole nother job or two or three or four. So those times where if your job is just to work on cases, when your mind kind of drifts, it drifts to your cases. If you put your name on the door, your mind sometimes going to drift to cases. Sometimes it's going to drift to like if recycling is getting taken, or to
Yep.
these human resource issues. So I just tell everybody, like, yes, it's a wonderful thing, but simply recognize that if all you want to do is try cases, then all you should do is try cases. If you want to be a firm owner and try cases, just know that you're going to become a firm owner and try cases. Just know that your plate is going to be divided in a different way and arguably fuller.
For sure. 1,000% agree. Nothing to add there.
All right, man. For folks who want to get in touch with you, you're just barred in Georgia, right?
Yeah, currently I'm gonna get waived into Mississippi. Probably gonna take California at some point and a few others. But yeah, currently in Georgia.
Yep. Yeah, I'm South Carolina. So for folks who want to get in touch with you about a case in Georgia, what is the best way for them to do that?
Sure, you can email me. My email is Joe, Joe, at TL, the number 4JGA.com. Or you can hit me on Instagram at Joseph Wilson ESQ.
And one of the things, man, your Instagram and your social media is so good. And like it's obvious why so many people around the state of Georgia and outside of Georgia reach out to you via social media. And it's also funny when, spending time with you one-on-one, just how soft spoken.
Yeah, I'm pretty quiet.
It's so good, man. And your social media is amazing, and I love like just the one-on-one time, the humility and the generosity of spirit. Your family's never far away, and man, it's just a real pleasure to call you a colleague and friend.
I appreciate that, man. I really do. We met a couple of years ago up in Montana, became instant friends up there hooping and getting better as trial lawyers. So great guy, great lawyer. We'll always be cool, man. We'll always be friends.
Appreciate you, man. Thank you so much for taking time to come on. Again, our guest today, Joseph Wilson from Trial Lawyers for Justice, Georgia. And you know how to reach him. So thank y'all so much for tuning in. And Joseph, we will see you soon.
All right, man. Thank you.
Yes, sir.